Good morning, San Diego. This is Fake News, and I'm Angelo Giuliana.
And my name is Sydney Hewitt.
And today we're bringing you breaking news concerning our Fourth Amendment rights to search and seizures.
Last night, suspect David Riley, who belongs to the Lincoln Park gang of San Diego, was involved in open fire against a rival gang member that was driving past them. Riley, along with a few other shooters, got into Riley's Oldsmobile and then fled the scene.
Here's a video of a witness that was at the scene.
Sir, what'd you witness at the scene?
I ain't no snitch. They were screaming everywhere, shooting, bang, bang, bang. I didn't know what to do. We're in a bad area too.
2 weeks later, Riley was pulled over while driving a different car for driving on an expired license registration tag. Because Riley's driver's license was suspended at the time of being pulled over, the police required that the car had to be impounded.
Before cars impounded, the police do a mandatory search of the car to protect themselves against claims that something had been stolen out of the car, to make sure it has all of its parts, and to see if they can find any contraband to charge the suspect with.
While the police searched Riley's car, they found 2 guns and arrested him for possession of firearms. Riley had his phone in his pocket when he was arrested, and a unit detective analyzed the videos and pictures on the phone to see if Riley was affiliated with the gang or not.
Riley was then actually tied to the gang shooting because of ballistic tests, which are tests that analyze the gun, its ammunition, and firing patterns. He was also charged with shooting at an occupied vehicle, attempted murder, and assault with a semi-automatic firearm.
We're now going to go live to an interview with the gang expert that testified Riley being part of the gang.
Sir, what did you say on trial?
Hello, my name's Kevin. I am a gang expert. Well, what I said was Riley tried to suppress pictures and videos found on his phone that tied him to the Lincoln Park gang, but his motion was denied. I've come to the conclusion that Riley was a part of the gang, and because of rivalries between the gang, and the shooting could have been gang related or revenge for bad business deals or to assert power over the other gang.
Now let's go to a live reenactment of Riley's arrest.
Wee-oo, 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 wee-oo. Tap, tap.
Hello, officer.
Pulled you over because your tags are expired and you have a suspended license. I'm gonna have to impound your car. Please
What
step
do
out of
you
the
mean?
vehicle.
You aren't getting me out of this vehicle.
Please don't resist. Just gonna do a quick search, alright?
Okay.
Do you have anything that might poke me or stab me?
Nah. I got nothing on me, man.
Oh, phone, huh? Some great stuff on this phone.
With the help of expert Mr. Anguizzaco, the jury concluded that he was guilty on all 3 counts for assault with a semi-automatic weapon, attempted murder, and shooting at an occupied vehicle. He was sentenced to 15 years to life in prison.
The question that a lot of San Diego residents have been asking is whether or not the evidence admitted from Riley's trial's phone was found through a case search that violated his Fourth Amendment rights. Let's go to the judge from the case.
The search violated Riley's Fourth Amendment rights. We characterized phones as mini computers, stuffed with a lot of important information so that distinguish it from other objects that would be taken during a seizure, like a wallet. Justice Alito suggested that the legislature create laws that draw distinct lines about can and can't be taken during a seizure.
And there's your beautiful baby. Any day now.
Really? You're eating Doritos? He's eating Doritos on my ultrasound. Do you see what I have to do?
I know.
Give me that.
One last thing. Let me start here with a Jeopardy-esque question. This would be in the category of lists for, say, $800. Candid photos of family, including 4 kids. Passwords to all social media and retail accounts. Medical history, personal and family. Birth dates of all immediate family. Detailed calendar appointments and cell phone numbers and addresses of family and acquaintances. And the question is, what could you find out about Michael if you had my iPhone? I raise this because tomorrow the Supreme Court is going to hear argument on a privacy debate that extends into your purse and into your pocket. At issue is whether law enforcement first needs a warrant before examining your smartphone. This debate arises from 2 cases, one of which involves a California man named David Riley. Riley was arrested in August of 2009 after a traffic stop resulted in the discovery of loaded guns in his car. Now, the officers seized Riley's phone without a warrant. Then they searched through his messages, his contacts, his videos, his photographs, and based in part on what they found in the phone, the officers charged him with an unrelated shooting that had taken place several weeks prior to the arrest. Look, our 18th century framers could never have anticipated that their words would apply to this 21st century conundrum. But still, they left us with adequate guidance as to how it should be handled. The Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. The question with regard to smartphones is not whether they can ultimately be searched, but whether their inspection should first require a warrant. There is a Fourth Amendment exception for searches incident to an arrest, and the issue now is whether smartphones ought to be in that category. The argument and the outcome are going to be interesting to watch because this one might be one of those rare Supreme Court cases that defies the 5-4 ideological breakdown. I'm hoping that the justices land on the side of privacy protection. My iPhone is a window into every aspect of my day-to-day existence, and the only way that law enforcement should gain access is by convincing a judge that they've got probable cause to take a look. As the New York Times noted in their lead editorial this morning, smartphone is a misnomer. They are personal computers that happen to include a phone function. Thanks for watching. I'm Michael Smerconish. I'll see you back here tomorrow night. CNN's special report with Don Lemon starts right now.
Now we're going to go to people in the streets to see what they have to say about search and seizures laws.
He should probably have a warrant or something for searching through someone's phone. That's an invasion of privacy.
I think it should be legal because he was legally pulled over, therefore they were allowed to search his car. I believe that no, it isn't legal because the phone had nothing to do with the reason why the cop pulled that guy over. So there is really no evidence to show that there was any reason to go through their phone.